So let's begin our today's session in relation to Bharatiya Sakshya Adhiniyam. So we have already completed what are the relevant facts which we can prove before the court to get the decision in our favor regarding the fact and issue which is asserted by one party and denied by the other party. So we have already completed all the facts which will be relevant under civil or any criminal trial, which can be proved by the parties by any type of evidence. So our next part, that will be of what type of evidences we can prove those relevant facts or facts in issue. ਹੁਣ ਆਪਾਂ ਇਹ ਚੀਜ਼ ਪੜ੍ਹ ਚੁੱਕੇ ਹਾਂ ਕਿ ਕਿਹੜੀ ਚੀਜ਼ ਨੂੰ ਆਪਾਂ ਕੋਰਟ ਦੇ ਵਿੱਚ ਪ੍ਰੂਵ ਕਰ ਸਕਦੇ ਹਾਂ, ਜਿਹਦੇ ਤੇ ਕੋਰਟ ਆਪਣਾ ਅਨੁਮਾਨ ਲਗਾ ਕੇ ਫੈਸਲਾ ਦੇਵੇਗੀ. So from now onwards we will study types of the evidences which are allowed by the Bharatiya Sakshya Adhiniyam, by which we can prove those relevant facts. So before starting with that part, we will be covering those facts which are not required by any party to prove before the court. So there are some facts which are already admitted by the court. So these facts are not required by the parties to prove. So those facts are dealt under section 51, that is the facts of which the court takes judicial notice. Judicial notice means, so the court presumes that these facts exist and these facts are correct. So the parties are not under obligation to prove those facts. So under section 52, so there is a list which is illustrative in nature. So there is a big list provided under section 52 of which court take judicial notice. So these facts include all the laws operational in our country. So that's why there is an interconnection with the Code of Civil Procedure, where Order 6, Rule 2, which deals with the general rule of pleading, which deals with general rules regarding the pleadings. So which states that the party who is presenting the plaint is only required to state the facts and prove the facts. So it is not under duty to state the law under which they are claiming their relief. So they are not duty bound to state the law or any statute under which the party is claiming the relief. So party ने सिर्फ facts ਨੂੰ state करना and state करके the party has to just prove those facts, not the law, because under section 52 of the Bharatiya Sakshya Adhiniyam, the court take judicial notice of that law or any kind of statute under which any party is claiming relief or any kind of other remedy from the court. So let's have a quick look at the section 52, which provides the illustrative list regarding the facts of which the court take judicial notice. समझ गए हो गल? Judicial notice means the court assume these facts exist. So parties are not required to prove these facts. So these facts include all the laws in force in the territory of India, including laws having extraterritorial operation. So all the laws which are in force in territory of India will be considered correct and proved by the court. Any kind of international treaty, agreement or convention with country or countries by India, or decisions made by India at international associations or other bodies. So any kind of international treaty signed by India in relation to any convention with any country, so that treaty will also have a judicial notice by the court. So all the course of proceedings of the Constituent Assembly of India, of Parliament of India and all of the state legislatures, so the court will have a judicial notice of all the proceedings of the Constituent Assembly or even parliament and the state legislatures of the various states. And the court will also have judicial notice of all the seals of the courts and tribunals. So this is the illustrative list. You can have a just a bare reading over the section 52. So after that we will be covering section 53, that are the other kinds of facts which are not required by the party to prove before the court, which are already admitted by the parties. So any fact which is admitted by the opposite party, so that fact will be considered as proved. So the party is not required to prove those facts. ਜਿਹੜੇ ਫੈਕਟਸ ਨੂੰ ਤਾਂ ਕਥਨਾਂ ਨੂੰ ਆਪਾਂ ਦੂਜੀ ਪਾਰਟੀ ਨੂੰ ਪਹਿਲਾਂ ਹੀ ਐਡਮਿਸ਼ਨ ਕਰ ਲਵੇ, then the opposite party is not required to prove those facts. So ਇਹ facts ਹੁੰਦੇ ਨੇ. So section 53 states that no fact needs to be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by in writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted by their pleadings. So ਇੱਥੇ ਗੱਲ ਸਮਝੋ, if the party admits during the hearing, during the trial, then it can be by oral or it can be in written. So that does not matter. But if any fact is admitted before the course of trial, so even before the trial the parties can also admit various facts, but those facts should only be in written form. Here oral admission will be of no consequence. So ਜਿਹੜੇ trial ਦੇ regarding in the course of trial facts ਜਿਹੜੇ ਆਪਾਂ admit ਕੀਤੇ ਆ ਉਹ orally ਵੀ ਹੋ ਸਕਦੇ ਆ ਤੇ in written form ਵੀ ਹੋ ਸਕਦੇ ਆ, but before the trial ਤੋਂ ਪਹਿਲਾਂ ਜਿਹੜੇ facts ਨੂੰ ਤੁਸੀਂ admit ਕੀਤਾ, that are only required in written form, and oral admission of any fact before the trial will be of no consequence. ਠੀਕ ਹੈ ਜੀ. ਸੋ ਇਹਦਾ ਇੱਕ ਪ੍ਰੋਵਾਈਜ਼ੋ ਵੀ ਆ. ਸੋ ਕੋਰਟ still has discretion. ਕੋਰਟ ਕੋਲੇ ਹਲੇ ਫਿਰ ਵੀ ਵਿਵੇਕਾਧੀਨ ਅਧਿਕਾਰ ਹੈਗਾ ਵਾ ਜਿਹੜੀ ਪਾਰਟੀ ਦੇ ਅਗੇਂਸਟ ਕੋਈ ਫੈਕਟ ਪ੍ਰੂਵ ਹੋਇਆ ਬਿਕੋਜ਼ ਆਫ ਐਡਮਿਸ਼ਨ. ਹੋ ਸਕਦਾ ਜਿਹੜੀ ਪਾਰਟੀ ਐਡਮਿਟ ਕਰ ਰਹੀ ਹੈ ਉਹ ਜਾਣਬੁੱਝ ਕੇ ਐਡਮਿਟ ਕਰ ਲਵੇ, ਜਾਂ ਫਿਰ ਉਹਦੇ ਤੇ ਕੋਈ ਪ੍ਰੈਸ਼ਰ ਕਰਕੇ, ਪ੍ਰੈਸ਼ਰਾਈਜ਼ ਕਰਕੇ, ਕੋਈ ਥ੍ਰੈਟ ਕਰਕੇ, ਕੋਈ ਕੋਅਰਜਨ ਕਰਕੇ ਉਹਨੂੰ ਜਾਣਬੁੱਝ ਕੇ ਐਡਮਿਟ ਕਰਾਇਆ ਗਿਆ ਹੋਵੇ, then the court has still discretion to require the facts to be proved by evidences. ਠੀਕ ਹੈ ਜੀ. ਹੋ ਸਕਦਾ ਨਾ ਜਿਹੜੀ ਆਪਣੀ ਪਾਰਟੀ ਆ ਜਿਹੜੇ ਫੈਕਟਸ ਨੂੰ ਐਡਮਿਟ ਦੂਜੀ ਪਾਰਟੀ ਤੋਂ ਕਰਵਾ ਲਵੇ ਧੱਕੇ ਨਾਲ ਜਾਂ ਪ੍ਰੋਮਿਸ ਨਾਲ, ਵਾਅਦਾ ਦੇ ਕੇ, ਜਾਂ ਅਨਡਿਊ ਇਨਫਲੂਐਂਸ ਨਾਲ ਵੀ ਤੂੰ ਫੈਕਟਸ ਨੂੰ ਐਡਮਿਟ ਕਰ. So the purpose of that, the court still has discretionary power to cause that party to still prove those facts which are even admitted by the other party. ਚਾਹੇ ਦੂਜੀ ਪਾਰਟੀ ਨੇ ਫੈਕਟਸ ਨੂੰ ਐਡਮਿਟ ਕਰ ਲਿਆ ਵਾ, ਕੋਰਟ ਆਪਣਾ ਡਿਸੀਜਨ ਦੇਣ ਤੋਂ ਪਹਿਲਾਂ ਜਿਹੜੀ ਦੂਜਾ ਪੱਖਕਾਰ ਹੈ ਉਸ ਨੂੰ ਫਿਰ ਵੀ ਕਹਿ ਸਕਦੀ ਹੈ ਵੀ ਤੁਸੀਂ ਫੈਕਟਸ ਨੂੰ ਪ੍ਰੂਵ ਕਰੋ, ਚਾਹੇ ਕਿ ਓਪੋਜ਼ਿਟ ਪਾਰਟੀ ਨੇ ਉਹਨਾਂ ਕਥਨਾਂ ਨੂੰ ਸਵੀਕਾਰ ਕਰ ਚੁੱਕਿਆ ਹੈ. ਠੀਕ ਹੈ ਜੀ. ਇਹ ਦੋ ਤਰ੍ਹਾਂ ਦੇ ਕਥਨ ਹੁੰਦੇ ਨੇ ਜੋ ਕਿ ਅਦਾਲਤ ਦੇ ਵਿੱਚ ਪ੍ਰੂਵ ਕਰਨ ਦੀ ਜ਼ਰੂਰਤ ਨਹੀਂ ਹੁੰਦੀ. ਕਿਹੜੇ ਕਿਹੜੇ ਨੇ? ਫਸਟ ਵਨ, the court which takes judicial notice of those facts, these are not required to be proved. And the second facts which are admitted by the parties or by their agents, that are also not required to be proved by the party. ठीक है जी. So now we will be starting the second part of the Bharatiya Sakshya Adhiniyam, which is most important, which deals with the types of evidences. So by which types of evidences we can prove these relevant facts or facts in issue. So these types of evidences are oral evidence, which is dealt under section 54 and 55, and second type is the documentary evidence, which is dealt from section 56. So let's begin with the oral evidence. Oral evidence ਕੀ ਹੁੰਦਾ ਵਾ? ਜੋ ਆਪਾਂ ਮੌਖਿਕ ਰੂਪ ਤੇ ਬੋਲ ਕੇ ਕੋਰਟ ਦੇ ਅੱਗੇ ਟੈਸਟੀਫਾਈ ਕਰਦੇ ਹਾਂ during the trial in a judicial proceeding, that is considered as oral evidence. ਕਿਹੜਾ ਹੋਊਗਾ oral evidence? The statement given on oath in a judicial proceeding, whether it is a civil trial or a criminal trial, that will be considered as a oral evidence. जो ਆਪਾਂ बोल के before the court we are testifying something by our words, by our spoken words, so that will be a oral evidence. ठीक है जी. So section 54 which states that all facts except the content of documents may be proved by oral evidence. So there is a rule regarding the how to prove the content of document that we will be studying under section 94. So as of now, you just keep one thing in your mind. Any fact can be proved by oral evidence except the content of the documents. So as of now, we will be doing section 54. Afterwards, when we will be studying section 94, then we will be covering how the content of any document which is required by law into written form or it is in written form, then how the content is proved. That we will study in our coming sessions. But as of now, you just keep one thing in your mind, that any fact other than content of documents can be proved by oral evidence. So after that, there is a section 55 which provides the general rule, which states that the evidence must be direct. Direct evidence means any fact which you have seen or you have heard or you have sensed by your five senses, or you have a common opinion regarding any fact. So the evidence must be direct, and its exceptions are the hearsay evidences. Any fact which is heard by any third person or seen by any third person or sensed by any third person, so those hearsay evidences are not admissible. So oral evidence must be direct, but it has some exceptions that we have already studied under section 6 and section 26A, which deals with dying declaration, and along with that we have taken res geste under section 4, which makes any statement or even conduct of any third person or bystander near the occurrence as a relevant fact. So that is an exception. But as a general rule under section 55, all the evidences must be direct. So direct evidences means any fact which could be seen by the witness who says he saw that fact, or any fact which is heard by the witness who says that he or she has heard those facts, or any fact which could be perceived by any other sense or in any other manner. It must be the evidence of a witness who says that he perceived it by that sense or in that manner, जो कि उसने महसूस किया वा. कोई भी कथन या कोई भी फैक्ट जो उसने महसूस किया वा अपनी सेंसेस दे नाल, ਉਸ ਦਾ एविडेंस दे सकता वा. And the fourth one, an opinion or to the grounds on which the opinion is held, it must be the evidence of the person who holds that opinion on those grounds. So opinion means थोड़ी राय किस बेसिस पे होती है? Based on your skill, based on your experience, based upon your any qualification that we have already studied under section 39, that is in relation to expert opinion. So any opinion that you hold regarding any subject will be also a direct evidence. ठीक है जी. So ये सीगे अपने oral evidence. So there are 4 types of oral evidences which are direct in nature. So all other facts which are perceived or heard or seen by any third person, and you are testifying before the court that and so third person has seen it, or third person has felt it, or third person has heard it, so that will be a hearsay evidence, and that fact cannot be admitted before the court. So you will not be allowed to give evidence of that fact unless you bring your statement or any fact under section 4, that is dealing with res gestae, or section 26 clause A, that is dealing with dying declaration, which states the cause of death or the circumstances that led to the transaction of a death. So you got my point? So the oral evidence must be direct in nature. It must not be hearsay evidence unless it falls under any exception of the Bharatiya Sakshya Adhiniyam, which is section 6 or section 26 clause A. So from tomorrow we will be starting with the documentary evidences. So there are two types of documentary evidences. One is primary evidence and second one is the secondary evidence. So the document itself will be a primary evidence, as the name suggests, and any copy or any type of any kind of printing or any something like that will be of secondary nature. So we will be studying the documentary evidence from section 56 from tomorrow. So if you feel any kind of doubt or any query, you can message me or you can comment below. Thanks. That's all for today. So from tomorrow we will be starting the documentary evidence.